Okay, let's dive into this by looking at our two main battlegrounds.
Now the CLAT? Well, think of it as a reading marathon. It's 100% passage-based. You're going to get an extract of about 200 words. Maybe it's a piece of new legislation, a recent judgment, or an article on, say, data protection. And then you have to answer multiple choice questions that test your direct comprehension of that exact text, plus your ability to apply it to a completely brand new hypothetical situation. The AILET, on the flip side, is a pure test of syllogistic deduction. It gives you a highly specific legal principle, follows it immediately with a fact scenario, and asks you to apply that principle to solve the case. Sometimes it even just tests named legal doctrines right out of the gate.
Now, before you start panic buying heavy, dusty legal tomes, just let this sink in. No prior law degree is needed. None. Both of these exams deliberately keep the actual legal content at a very basic, intuitive level. You really don't need to walk into the room knowing the intricacies of the Indian Penal Code. You already possess the primary tool you need to succeed here, which is just your own sense of logic.
Which brings us to the real secret sauce of this whole thing. It isn't about memorizing laws at all. It's about precise application.
Here is the golden rule, the one thing you need to remember. The trap is almost always in careful reading. I absolutely cannot emphasize this enough, guys. Because the examiners know the law they're giving you is relatively straightforward, they're not trying to trick you with complex, abstract jurisprudence. Instead, they are aggressively testing your attention to detail. The trap is literally right there in plain sight, just hiding in the text.
For example, two options on a multiple choice question might look totally identical, but they differ by a single tiny qualifying word. The difference between an action that always happens versus one that may happen. Yeah, that's the difference between winning a multi-million-dollar case and getting laughed straight out of court. Conflating an employer with an employee entirely flips the dynamic of a legal dispute. Spotting these tiny single-word shifts in the logical syntax is the ultimate key to unlocking the right answer. You essentially have to train yourself to read like a machine.
Now, what's really interesting about this slide is how we actually put this strict reading into practice. Let's look at a CLAT-style case study on consumer protection.
I'm going to pause for just a second, mentally lock in your choice.
First, let's decode the statutory jargon into plain English. A deficiency in service is simply a failure to meet a standard that was either promised to you or required by law. But, and this is a huge but, here are the vital qualifiers. Consideration, which is just a fancy legal word for payment, must have been given. If you get a free service, you generally cannot claim a deficiency under this specific statute. It also expressly does not apply to a contract of personal service, which typically means an employer-employee relationship.
Okay, here is a direct excerpt from our simulated source passage. Listen closely. A complaint for a deficiency in service can be filed even where no formal written contract existed, as long as the consumer paid consideration for the service. When you read something like this, you have to anchor your logic exclusively to this text. Do not bring your outside assumptions into it. This text, right here, that is your entire universe.
All right, let's step into the shoes of the lawyer. Here are the facts. Ramesh takes his car to a garage. The garage verbally promises a complete engine check for 2,000 rupees. Ramesh says, great, and agrees. But when he eagerly goes to pick up his car, they've only cleaned the exterior. They never even touched the engine. So the big question is, what can Ramesh claim under the law we just learned?
Let's weigh our legal options here. Option A argues Ramesh can claim nothing, specifically citing the lack of a written contract. Option B states he can claim a deficiency in service because the promised standard wasn't met despite his payment. Option C counters with nothing, claiming car servicing as a personal service contract. And Option D asserts a deficiency in service, but adds that it only applies if the garage operates as a registered company.
So the crucial point is how methodically we eliminate the wrong answers. Step 1, we isolate the rule. Payment is enough. A written contract isn't needed. Step 2, we map those options. Option A is immediately wrong because the passage explicitly told us no formal contract is required. Option C completely misapplies the term personal service. Repairing a car is a paid commercial service, not an employment relationship. And option D, that is a classic trap. It adds an entirely invented detail. The passage never said a single thing about the garage needing to be a registered company. We just eliminate it on that technicality alone.
And that leaves us with our confirmed answer, option B. It matches our rule perfectly. Ramesh paid consideration, the 2,000 rupees, and the garage utterly failed to deliver the promised standard of a complete engine check. If you picked B, great job applying the text exactly as it was written.
All right, let's ramp up the energy with our second challenge, an AILET-style case study on WhatsApp defamation.
Before we look at the exam text itself, let's break down the core elements of defamation. Defamation requires three very specific things. First, a false statement. Second, it has to be communicated to a third party, meaning someone other than the person you're actually talking about. Third, it has to actually damage that person's reputation. However, there are two massive exceptions where it isn't defamation at all: if the statement is factually true, or if it was made in good faith to protect one's own interests. So here's exactly how it would appear as a formal legal principle on the exam. A person is liable for defamation if they make a false statement about another person communicated to a third party that damages the reputation, unless the statement is true or made in good faith. I really want you to keep this specific wording in your mind's eye as your visual anchor for this next scenario.
Okay, picture this relatable modern scenario. Anjali gets into a petty dispute and decides to tell her entire apartment building's WhatsApp group that a fellow resident, Vikram, has been stealing newspapers from other flats. She has absolutely zero evidence, and it turns out to be entirely false. But because of her message, several neighbors start treating Vikram with suspicion and actively avoiding him in the hallways. Based strictly on the principle we just read, is Anjali liable for defamation?
Let's lay out the traps. Option A says no, because she only shared her opinion, not a hard fact. Option B argues no, because private WhatsApp groups don't count as public third parties. Option C says yes, because she made a false statement, communicated it, and it damaged his reputation. And option D says yes, but only if Vikram can prove he lost actual money because of it. Look really closely at the traps here, guys. If you aren't referencing the exact principle, A, B, and D all sound incredibly plausible in the real world, don't they?
And this brilliantly illustrates the power of rigorous step-by-step logic. Let's run down our checklist. Was it a false statement? Yes, she accused him of theft without evidence, and it was simply untrue, which completely dismantles option A's claim of it being a mere opinion. Was it communicated to a third party? Yes, a group chat full of neighbors certainly counts, knocking out option B. Was his reputation damaged? Yes, the neighbors grew highly suspicious. Did she hit any exceptions? No, it wasn't true, and baselessly accusing someone isn't good faith self-protection. Finally, look at option D. It demands proof of financial loss. But remember the legal principle we read? It said absolutely nothing about financial loss, only reputational damage. D is an invented requirement trap.
Which leaves us with the mathematically precise answer, option C. Yes, Anjali is liable. All three elements of the stated principle were strictly satisfied, and no exceptions applied. There is a deep, profound satisfaction in cutting through all that noise and arriving at the correct answer through pure logical deduction, isn't there?
The trap is always in the wording. Whether you're facing down a 200-word CLAT passage or a dense AILET principle, your new superpower is ignoring outside assumptions and reading exactly what is right in front of you. Spot the always, spot the may, and absolutely refuse to accept invented details. This mindset doesn't just help you ace exams, it genuinely changes how you process information daily. So the next time you sign a contract or even send a heated text message, are you reading it like a lawyer?
Just trying to wrap your head around the legal world a little bit better? Consider this your official invitation. Subscribe to Detiksha Legal. It is a space designed specifically for you to learn, question, and explore.